This video provides a focused overview of Topic 7 of the RE5 exams. The title for Topic 7 is Dealing with Complaints that have been submitted to the Ombud for FSPs. Definition of complaint, in terms of the FAIS Act. Complaint means, subject to Section 26(1) a specific complaint relating to a financial service rendered by a financial services provider or representative to the complainant on or after the date of commencement of this Act, and in which complaint it is alleged that the provider or representative has contravened or failed to comply with a provision of this Act and that as a result thereof the complainant has suffered or is likely to suffer financial prejudice or damage. Has willfully or negligently rendered a financial service to the complainant which has caused prejudice or damage to the complainant or which is likely to result in such prejudice or damage. Or has treated the complainant unfairly. The role and authority of the Ombud for FSPs. The role and powers of the Ombud, sections 20 to 32. The FAIS Act makes provision for the appointment of an Ombud for financial services. The function of the Ombud for financial services providers, FAIS Ombud, is to resolve disputes relating to the rendering of financial services by providers where they have either failed to comply with the FAIS Act or where as a result of either willful or negligent conduct by the provider the client has suffered or will potentially suffer prejudice or damage. The following fundamental principles apply to the role of the Ombud for financial services providers, FAIS Ombud. The Ombud for financial services providers, FAIS Ombud, acts independently and objectively and takes no instructions from any person regarding the exercise of authority. The services rendered by the Ombud are not to be construed as being similar to those of a professional legal advisor and are confined to the investigation and determination of complaints in terms of the Act and the rules. The objective of the Ombud Office. The objective of the Ombud Office is to provide a fair, unbiased, reasonable, economical and expeditious relief to the ordinary person in the street at no charge. Section 20(3) of the Act. The Ombud for financial services providers is a body created through law. There are other voluntary ombudsmen created by the financial services industry who also deal with financial disputes, such as the Ombudsman for banking services. Since 1 April 2005, the Ombud for financial services providers was granted the authority to act as statutory ombud in terms of the Financial Ombud Schemes Act 2004, Act No. 37 of 2004. FSOS Act. This means that the Ombud for financial services providers can deal with complaints where there is uncertainty over jurisdiction and where the other voluntary ombudsmen do not have jurisdiction. The powers of the Ombud for financial services providers, FAIS Ombud. The FAIS Ombud is mandated to investigate and adjudicate complaints by clients against FSPs and representatives. These complaints could relate to a number of areas of non-compliance with the various codes of conduct promulgated under the FAIS Act, and where a financial service has been rendered negligently and where someone has willfully committed misconduct whilst rendering a financial service. The FAIS Act requires that when adjudicating a complaint, the FAIS Ombud must consider the contractual or other legal relationship between the parties and ultimately do what is equitable in the circumstances. Compensation could vary from ordering the complainant to be placed in the position in which she or he would have been had it not been for the misconduct of the representative, or simply correcting a misunderstanding. It all depends on the circumstances of the particular case. Jurisdiction of the Ombud for financial services providers, FAIS Ombud. The following jurisdictional provisions apply to the Ombud in respect of the investigation of complaints. The Ombud has a jurisdictional limit of R800,000. The complaint must not constitute a monetary claim in excess of R800,000 for a particular kind of financial prejudice or damage, unless the respondent, the FSP, has agreed in writing to this limitation being exceeded, or the complainant has abandoned the amount in excess of R800,000. The Ombud must decline to investigate any complaint if proceedings have already been instituted in any court in respect of the act or omission. The Ombud may, on reasonable grounds, determine that it is more appropriate that the complaint be dealt with by a court or through any other available dispute resolution process and decline to entertain the complaint. If a case cannot be settled through mediation or conciliation, the FAIS Ombud or the deputy FAIS Ombud may issue a determination. A determination has the same legal effect as a judgment of a court. Obligations of the FSP in respect of an investigation conducted by the Ombud for FSPs. The management and oversight duties of the key individual include the management of processes to ensure that the business cooperates in the case of an investigation by the Ombud or the FSCA. FSPs must try to resolve complaints and disputes with clients first, and if there is no agreement or settlement, the client can approach the Ombud. The FSP must provide adequate contact details of the Ombud to clients. The Ombud will typically consider a complaint in the following circumstances. If the complainant alleges that a financial services provider or its representative has contravened or failed to comply with the provisions of the FAIS Act and as a result thereof the complainant has suffered or is likely to suffer financial prejudice or damage. Willfully or negligently rendered a financial service to the complainant which has caused prejudice or damage to the complainant or which is likely to result in such damage. Treated the complainant unfairly. Procedures when investigating a complaint. 1. The complainant completes a complaint form and submits it to the Office of the Ombud for Financial Services Providers, FAIS Ombud. The Ombud may insist that the complaint be referred to and dealt with by the FSP first. 2. The Ombud must inform every other interested party to the complaint that they have received it. 3. All parties must be provided particulars to enable them to respond to the complaint. 4. All parties must be afforded the opportunity to submit a response to the complaint. 5. The Ombud may implement any procedure including mediation which he deems appropriate and may allow any party the right to legal representation in considering the complaint. 6. The Ombud may ask the respondent, FSP or representative, to discuss the complaint and provide any relevant information that the Ombud may require. 7. The Ombud will in the first instance explore any reasonable prospects of resolving a complaint by a conciliated settlement acceptable to all parties. 8. He may make a recommendation to speedily resolve a complaint and require the parties to confirm in writing whether or not they accept the recommendation. Procedures when investigating a complaint, continued. 9. Where the parties accept the recommendation will have the effect of a final determination by the Ombud as outlined in Section 28(1) of the FAIS Act. 10. The Ombud may dismiss the complaint if he is of the view that the offer made by the FSP is fair. 11. If the complainant is unhappy with the Ombud's determination, he or she may appeal to the tribunal, provided the Ombud grants leave to appeal. Note: if the Ombud refuses leave to appeal, the applicant must be advised in writing of such refusal. The applicant may within 1 month of such refusal apply to the chairperson of the Board of Appeal for leave to appeal against the determination, and advises the Ombud in writing accordingly. 12. Where a matter has not been settled or a recommendation has not been accepted by the parties, the Ombud shall make a determination which may include a. dismissing the complaint, or b. upholding the complaint, wholly or partially. Procedures when investigating a complaint continued. 13. The complainant may be awarded an amount as fair compensation for any financial prejudice or damage suffered. 14. A direction may be issued that the authorized financial services provider, representative or other party concerned take such steps in relation to the complaint as the Ombud deems appropriate and just. 15. A determination or final decision of the Board of Appeal, as the case may be, is regarded as a civil judgment which shall be recorded by the clerk of the court or commissioner of the High Court as the case may be. 16. A warrant of execution may be issued in the case of a determination or final decision of the board which amounts to a monetary award and may be executed by the sheriff of the court after the expiration of a period of 2 weeks, after the date of the determination or final decision of the board as the case may be. Processes must be in place to ensure that the FSP cooperates in the case of an investigation by the Ombud. The key individual must ensure that there are adequate processes in place and that staff are informed and trained with regard to the handling of complaints submitted to the Ombud and any investigations by the Ombud's office. If a person does something in relation to the FAIS Ombud or in relation to an investigation by the Ombud, which could be regarded as contempt of court by a court, the person is guilty of an offense and liable on conviction to a penalty which could have been imposed by a court. A person who anticipates a determination of the Ombud and does something to influence the determination or who willfully interrupts any proceedings of the Ombud, is guilty of an offense and liable on conviction to a fine or to imprisonment for a period not exceeding 1 year. Case fees, costs and interest. In terms of the FAIS Act, read with Rule 9, of the Rules of Proceedings of the Office of the Ombud for financial services providers. The FAIS Ombud may charge a case fee of up to R1000 once a matter has been accepted for investigation. This fee was discontinued when the Office of the Ombud announced that the case fee will no longer be charged with effect from 10 September 2012. When making a final determination in terms of Section 28 of the Act, the Ombud may grant costs against the respondent or, in the circumstances contemplated by Section 28(2)(b)(e), against the complainant, in either case in favor of the other party to the complaint or in favor of the office. Any costs awarded by the Ombud must be quantified by the Ombud with due regard to the nature of the complaint, the time spent on the complaint, the expense and inconvenience caused to a party, the conduct of a party in resolving the complaint and any other factor deemed by the Ombud to be appropriate. Penalties. Any person who commits any act in respect of the Ombud or an investigation by the Ombud which, if committed in respect of a court of law, would have constituted contempt of court, is guilty of an offence and liable on conviction to any penalty which may be imposed on a conviction of contempt of court, or anticipates a determination of the Ombud in any manner calculated to influence the determination, or willfully interrupts any proceedings conducted by the Ombud, is guilty of an offence and liable on conviction to a fine or to imprisonment for a period not exceeding 1 year.